Hello, everyone. Welcome in. We have been waiting quite some time for movement on the Alexee Trevizo case. Just a quick recap. The district judge, the judge presiding over Alexee's criminal case, did indeed basically throw out all of the evidence of Alexee in her hospital room and any statements made to her medical providers on the night of the alleged crime. The state has appealed that decision to the New Mexico Supreme Court. We have been waiting for the defense in that case to file their answer brief in the Supreme Court, which has finally just happened a little over a week ago. And we have a quick response to supplement the record from the state as well. I just got these and I was not able to go through the entire set of these documents. I've basically glanced through the first page. So this will be kind of a cold read of the defendant's answer brief to the Supreme Court, appealing on the evidence in the Alexee Trevizo case. I'll try and get us into it as quickly as possible, despite any little disclaimers I have, because this one will be a long one. Thank you for being here, and justice for baby Alex. Let's go. All right, before we get too deep into these documents, real quick, I will say I am going to bring you the facts. I am biased in this case. I am of the personal belief that Alexee is guilty. Of course, I'm not on the jury. I won't be on the jury, so my opinion really doesn't matter. But again, that is my opinion. But I will always remain truthful and honest in delivering you the facts. If something is good for my side, my thoughts and beliefs, I'll say it. If it's bad for my side, my thoughts and beliefs, I'll say it, because being honest about the issues is the only way to win in the end when it comes to the law. If you can't accept the bad facts, impacting your issue in the case, then you might as well pack it up and call it a loss. So you have to learn how to get around those and how to frame those in your favor. So with that being said, we will be honest about any and all of the facts that are in this answer brief from the defense in the Alexee Trevizo case. Once again, they are trying to keep the evidence from the hospital that has been deemed against Alexee's privilege rights and the footage, the body cam footage of Alexee Trevizo in that hospital room out, because the district judge has kept all of that particular evidence out. And the state does think that that is evidence they are allowed to have. And so they are appealing to the Supreme Court. The defense had to make their move. That is this document right here. I went past the first page because it just has all their addresses and everything. Pretty irrelevant. All right, so let's get down to business. With this, I believe it's 44 pages, so I'm going to try and get through literally all of it, so strap in. Let's do the thing. So oral argument has been requested. This case constitutes the first time New Mexico Supreme Court has considered how pregnancy outcome criminalization impacts federal and state constitutional questions regarding Miranda warnings, the line between healthcare providers and law enforcement within a hospital setting, and the public policy implications of both these issues for New Mexicans. For these reasons and the fact-specific nature of this appeal, defendant appellee respectfully requests that the court grant oral argument in this matter, which is essentially where you get to have a debate in front of the Supreme Court. They will grill you with questions. Sometimes typical standard trial attorneys don't do oral arguments. They will bring in outside counsel because it is a very specific skill. Not that trial attorneys can't do that or be cross-trained. It is just definitely a very specific skill. So it will be interesting to see who does oral argument for this, because Gary Mitchell does seem to be pretty well-rounded. I don't know if he has a lot of Supreme Court history, but it appears that the state has brought on someone specific to handle this, which we will get to towards the end of this video after we get through this document. To counter summary of proceedings, every person entering an emergency room deserves compassionate, competent, and confidential health care. Accessing this care does not require a sacrifice of constitutional and statutory rights. Despite these basic truths, The state asks this court to condone its violation of defendant appellee Alexee Trevizo's constitutional right against self-incrimination and to ignore the protections guaranteed to her by the physician-patient privilege under Rule 11504 Mexico rules. Alexee asks this court to reject these attempts and offers this counter summary of proceedings pursuant to Rule 12318B to address the state's incomplete and incorrect narrative of the facts in this case. Following an unexpected and traumatic labor and delivery in Artesia General Hospital Restroom, Alexee Trevizo, then a 19-year-old high school senior, was subjected to a custodial interrogation orchestrated by law enforcement and hospital staff. Having determined that Alexee was pregnant and having given her an array of mind-altering pain medications, hospital staff entered Alexee's room side by side with armed police officers. By then, police and hospital staff had already conferred with each other to initiate a murder investigation in the hospital emergency department with Alexee as their only suspect. Alexee's own physician interrogated her while police watched, listened, and blocked the small treatment room's only exit. Their collective presence in Alexee's room was not for the purpose of diagnosis or medical treatment, but to accuse Alexee of criminal wrongdoing. There's so much wrong with this already. Rather than immediately airlifting Alexee to a facility capable of treating her baby having emergency, a potentially life-saving measure the physician herself deemed necessary, she did get on they had to get the airlift there. Y'all are just mad that the police made it there quicker. This wouldn't happen if it didn't, if they weren't right by and didn't get there that quick. You guys are just salty about that. So sorry, guys. Rather than immediately airlifting Alexee to a facility capable of treating her emergency, a potentially life-saving measure the physician herself deemed necessary due to Alexee's severe postpartum bleeding, Alexee's physician collaborated with police to advance an investigation into Alexee as a criminal suspect because of where they found the baby. This decision was one of a cascade of failures by hospital staff that prioritized a law enforcement agenda over Alexee's medical needs, undermining her rights to due process and privacy and eroding the trust that forms the bedrock of physician-patient relationships. In considering these facts, the district court found that 1. Alexee's physician acted as an agent of law enforcement. That's interesting. Like we said here before, doctor just magically turned into a police officer herself, completely disregarding their other argument about waiving statements made to hospital, staff, doctors, caregivers, whatever. You admit that she's a caregiver there, but she's also law enforcement when it suits. It's just, this is the parts that get you frustrated. The confrontation the physician coordinated with police amounted to a custodial interrogation. Okay, so let's just break this down. Confrontation the physician coordinated with police amounted to a custodial interrogation. So the fact that the doctor told Alexee why the police are there and why she found the baby and why she has to order this airlift for Alexee, you, in 2 words, call it 2 separate things, a confrontation and an interrogation. Which is it? Because those are very different in the eyes of the law, and y'all are gonna lose in the Supreme Court, I'll tell you what. Alexee's statements made during that custodial interrogation, now it's not a confrontation, it's an interrogation now. Alexee's statements made during that interrogation without Miranda warning or waiver must be suppressed. Additionally, the district court correctly held that Alexee's communications made while seeking medical treatment were intended to remain confidential, thus rendering them inadmissible pursuant to Rule 11504. I hope after this case I never have to see Rule 11504 ever again in my life. I've read it a million times. Rather than address the systemic failures detailed by the district court's findings, the state exploits the derelictions of hospital staff and police for prosecutorial gain. Wow. That's just low, honestly. They're basically saying that they're just trying to get Alexee no matter what it is, and that they don't think that there's really legal grounds for it, that this is just dirty prosecutors, which, if that's what you think is going on in this case, I highly suggest you go look at Delphi and look at what's going on over there, and you tell me that this is a prosecutorial gain over here. That's absolutely wow. I told you guys I'm reading this for the first time, so I'm sorry if some of these reactions are taken aback. That's like fighting words. So that's pretty messed up. Affirming the district court's suppression of Alexee's unlawfully obtained statements is essential to uphold the constitutional guarantees protecting defendants against self-incrimination and to maintain public trust in the New Mexico healthcare system's ability to protect and prioritize patient care and confidentiality. Emergency departments must maintain a clear boundary between healthcare and law enforcement, lest they undermine their most fundamental purpose, patient care. Here, police and hospital staff disregarded that boundary, instead turning private actors into state agents. Wait, private actors? Interesting. Okay. Private actors into state agents. I don't know. I thought you were considering them federal actors when you're throwing in HIPAA into a criminal case, but hey, I guess they're private actors now. Anyways, instead turning private actors into state agents whose interests were to advance a criminal investigation, rather than address the failures that contributed to the tragedy at the heart of this case. No, you're not getting away with that. The tragedy at the heart of this case was that a baby was put in a trash bag and given no chance in a hospital. You delusional piece of... Oh my gosh. I literally hate this filing. You guys, this is low. The tragedy at the heart of this case. Justice for baby Alex. For these reasons, this court should affirm the district court's findings. Summary of facts. At around midnight, January 27, 2023, Alexee Trevizo presented to the emergency department at Artesia General Hospital seeking treatment for severe lower back pain. Notice how she did not mention her stomach. Alexee reported to attending physician Dr. Heather M. Vasquez and emergency department nursing staff that her pain began after cheerleading practice earlier that afternoon, which, if I can just interject, had them rightfully thinking she might have hurt her back. She's saying her back hurts and that she cheerleaded. I'm thinking back injury. When asked if she was pregnant, Alexee told the staff she was not, citing... Hold on. When asked if she was pregnant, Alexee told staff she was not, citing vaginal bleeding in the preceding weeks and stating she was currently on her period. That doesn't make sense. Hold up. Wait a minute. Why are you bleeding so much? Shouldn't you be questioning that? She bled in the preceding weeks. Was that, you mean last month? Or she'd been bleeding throughout all these weeks and then was currently on her period again? I don't know. That already just doesn't add up, right? Like, it's like, I don't know. You could have said that she had her period the month prior and that she was currently on her period again. It seems like they might think that there's evidence to the contrary that the state will put forward, that let's just see here, because that's a very interesting way to put that catches my eye. Citing vaginal bleeding in the preceding weeks and stating she was currently on her period. That could have been put way more clearly, unless you know something we don't know that the state is going to use against you. At 12:28 a.m., staff ordered a pregnancy test, a standard practice for patients of Alexee's age and with her symptoms. Around the same time, staff administered various IV pain medications to Alexee, including cyclobenzapine, ketorolac, ondansetron, and morphine. At 12:51 a.m., both Dr. Vasquez and nursing staff were notified that the pregnancy test was positive. Actually, you can't put it that way. you have to say that notice of the positive pregnancy test came through. Because we don't know exactly when they saw it, technically. Like, they said they saw it when they saw it. Like, we don't know when they looked at their laptop or their little, like, wherever it reports to. We don't know when they actually looked at it. So that's improperly phrased, in my opinion. Were notified that the pregnancy test was positive. Despite this result, despite Alexee reporting vaginal bleeding, so are we going to talk about what she reported? Are we going to talk about what she reported? Because apparently, according to the people there, she was clear she could not be pregnant, which you'd think someone who is honest would say it could be a possibility. I mean, yeah, I'm bleeding, but I've done the deed, so it could always be a possibility. That's just how I see it. Anyways, despite this result and despite Alexee's reporting vaginal bleeding, neither Dr. Vasquez, the treating nurse, or the charge nurse informed Alexee of her pregnancy or altered her medications or treatment. Yeah, because nothing was affecting it. Alexee's precipitous labor and delivery. Precipitous labor. I'm almost 100% certain that means like it just sprung up on her. She didn't know it was coming. Hold on, I'm Googling. Precipitous. Born, okay, when a baby's born without 3 hours of regular contractions. Oh, okay. False. Lies, 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 lies. Precipitous labor. You best not be saying that it's precipitous labor. How do I know? Because her boyfriend said that earlier in the night, way before 3 hours of going to the hospital, how bad her back and everything hurt. She was experiencing contractions, whether this dumb knew it or not. I think she did, in my opinion. But that's actually just not true. Precipitous labor means it just sneaks up right on you. You're like, oh my gosh, I knew I was pregnant, but like we didn't know the labor was going to come that fast, baby come that fast. No. That's not true. Alexee's precipitous labor and delivery. At 1:39 a.m., 48 minutes after Dr. Vasquez and the treating nurse, Chris Sanchez, became aware of Alexee's positive pregnancy test, Alexee told her medical team she urgently needed to have a bowel movement. We're not going to read these little bottom citations. Actually, yeah, let's read them. Number one, because the record proper contains only one volume to date, citations to it do not include a volume number. Number two, the urge to have a bowel movement is a common sign that labor is moving into the delivery phase and that the cervix is fully dilated. No one cares about that fact in this. Nurse Sanchez unhooked Alexee's IV and allowed her to go to the restroom unaccompanied. She ran down the hallway, so she didn't really appear to need to be accompanied. Let me at the oral arguments. Tag me in, coach. I want to argue this because you don't necessarily have to argue law. Well, like you do, but you also can argue facts. Like it's like, no, these are the facts. Let's argue the facts here. She ran down that hallway to the restroom unaccompanied. Facts. Hospital security camera footage shows Alexee. Oh, look right there. You guys, I'm sorry. I got too pumped up. Hospital security camera footage, they admit themselves, shows Alexee running down the hallway and past the nursing station, clutching her backside. Y'all admit to that? Wow, that's crazy. Hospital footage shows at 7:51, over the next 19 minutes alone in the restroom, Alexee endured a precipitous labor. Why did she not call for help? And delivery, resulting in the birth of a newborn. Call for help. She described as not moving, crying, or breathing. Again, call for help. Although her mother and Nurse Sanchez periodically knocked on or stood outside the door during those 19 minutes, no one, not her physician or hospital staff, entered the restroom. No one reported hearing a baby cry. Oh, interesting. I understand them trying to make this point, but to me, all that says is that she put the baby in the trash real quick and that the baby ran out of oxygen real quick. You're not going to convince me that all the signs in the autopsy that the baby was born alive aren't true. I'll continue. At 1:57 a.m., Alexee returned unassisted to her bed in the emergency department. Minutes later, Dr. Vasquez ordered a transvaginal ultrasound as Alexee was bleeding profusely. At 2:20 a.m., Dr. Vasquez performed a pelvic exam on Alexee for the first time. Despite noting a significant amount of blood, multiple extremely large clots and Alexee's wide open cervix, Dr. Vasquez still did not discuss Alexee's emergency condition with her or inform her of her prior positive pregnancy results. That's interesting. I don't know if that's going to come out as true. I do believe that the doctor likely told Alexee the reason for the pelvic exam. I 100% believe that. And I think that if these facts are being alleged, it's only fair that all of the hospital staff gets to say exactly what happened, no holds barred, because you're not going to get to try and, make them look bad and put them on their heels to where they can't explain themselves or their actions. Because as far as I'm aware, why would Dr. Vasquez be doing a pelvic exam and not explain why? That doesn't make sense. The discovery of the stillborn, hold on, I wasn't ready to read that sentence. The discovery of the stillborn and the introduction of law enforcement. No, this is wild that they even get to put it this way due to the autopsy. You can't just fully disregard the autopsy and be like, it's 100% wrong. Everything they said about the autopsy is wrong. Everything that came out and it's wrong. And it's a stillborn as this baby. No, it's baby Alex, and he was born alive according to the autopsy. Get it right. After being called to clean up large amounts of blood in the bathroom, cleaning staff found the newborn in the restroom waste bin at 2:27 a.m. in the trash can. I am not going to give it any kind of prettier words than what it was. In a trash can. Dr. Vasquez did not attempt resuscitation and immediately pronounced the newborn deceased at 2:28 a.m. because the newborn was clearly deceased. Realizing that Alexee was not just vaginally bleeding, but had just given birth and, quote, could die from postpartum hemorrhage, Dr. Vasquez contacted Loveless Regional Medical Center. Wait a minute. Up above, didn't you just say that they completely ignored life-saving medical care and instead colluded with the police instead? Because I don't hear about no police being called before this phone call, which I've talked about because I watched the hospital footage and I saw the phone call to the police and I saw how everything played out. And that happened after the doctor had already been working on Alexee. The doctor immediately leaves after they pronounce the baby dead and turns the attention to Alexee and getting Alexee life-saving care. You guys just owned yourself. You just owned yourself because that is a fact. 100% fact. And up above in this pleading, you contradict yourself saying that the doctor didn't give any care to Alexee for this life-threatening condition, but she did. It was the first thing she did after pronouncing the baby dead. You owned yourself. You owned yourself. You deserve that for this title of discovery of stillborn. You deserve to have owned yourself in here as bad as you just did right there. Dr. Vasquez contacted Lovelace Regional Medical Center in Roswell to arrange an urgent transfer. An urgent transfer! Would imagine that. Dr. Vasquez later confirmed, however, that she would not re-examine Alexee or discuss Alexee's condition with her until law enforcement were present as witnesses. Actually, that's not how she said. She came up and saw them after going and trying to do this care transfer and set all of this up. The police got there really fast enough that the doctor hadn't even gone to see Alexee. Not intentionally, but that's just how the facts played out. And that's what the defense is most mad about, because the doctor would have been forced to go see Alexee and deal with her and everything like that before the police got there if they hadn't been there so quick. The time would have ran out. She would have been done contacting Loveless and would have had to go see Alexee. You actually see the doctor show up on the police body cam and start talking to them and say, I just got her transferred. I'm going to go in there and tell her, do you want to be witnesses? That's how it happens. She doesn't wait nefariously. She doesn't intentionally not help Alexee or do anything for Alexee. And in that moment, there's nothing the doctor does or could do. The doctor is essentially just trying to get her to where they actually can treat her correctly. So this is a very disingenuous point here. So refused to discuss her, or would not re-examine Alexee or discuss Alexee's condition until law enforcement are present as witnesses. Dr. Vasquez also instructed her team to not speak to Alexee until police were present. Sleep body cam. I don't remember her ever saying that. I don't believe that's true. Once police arrived, charge nurse Hillard HT was the first to confer with them at 2:38 a.m. The custodial interrogation. This is where we really want to get to, because who are they going to say interrogated her? Obviously, probably the doctor, but I truly think it was Rosa, and the police just happened to be in the room. So I don't know. This will be an interesting argument. The custodial interrogation. Charge nurse immediately engaged with Artesia Police Department, a sergeant and officer, and told them that Alexee went to the restroom with the intention of harming her pregnancy and that she killed the kid. I mean, that's what pretty much everyone thinks. Dr. Vasquez quickly joined the conversation. Yeah, because she came from calling Loveless to get life-saving care for Alexee, informing the officers that she had not yet told Alexee, quote, what was going on, or about her need for an urgent medical transfer, because she had just set it up. At Dr. Vasquez's request, the officers agreed to immediately enter Alexee's room together with Dr. Vasquez and the charge nurse. Yep. After 2:41 a.m., having conferred about this joint approach, the two fully armed male police officers don't care about that at all. The male charge nurse don't care. Wow. Is she going to insinuate that because they're dudes, it has any like extra? I'm saying she because I'm fairly certain Amber Faderberg wrote this. I just don't care that they're men. Okay, you're not going to pull this with me that they're more intimidating as men. I truly could care less. That is just bullcrap, and you guys are arguing with yourselves at this point. But hilarious. These big bad scary men entered the room. The male charge nurse and Dr. Vasquez entered Alexee's room. Dr. Vasquez positioned herself at Alexee's bedside while the officers and the charge nurse blocked the doorway. Body camera footage shows Alexee and her mother and emergency contact, Rosa Rodriguez. Let's go back up to this little spot. While much of the footage does not show the officers, but only their perspectives via body-worn cameras, the footage clearly shows the layout of Alexee's room and the position of the involved actors relative to the doorway. Oh, so they're kind of conceding that the doctors, that they weren't like blocking the door, right? They weren't like guarding her from the door. In fact, quite the opposite. They weren't like standing in front of the door saying, you can't get out of here even if you walked away. They did say that you're not free to go, so don't try and leave, but they didn't like intimidate her with their body language. So they're kind of having to concede that there. Anyways, with her emergency contact, Rosa Rodriguez, glancing anxiously between the physician and the police officers. So, like, you should know you just threw a baby in the trash. Like, yeah, police might get involved. Why didn't you just tell anyone what the hell happened? That's why I think it's going to get political here. That's just my guess. We'll see. Once the collective group entered the room, Dr. Vasquez told Alexee, we discovered a dead baby in the bathroom. While it was Dr. Vasquez who spoke first, Officer Williams and Anaya later attributed this sentence to APD, reporting that they had informed Alexee that a baby was found in the trash. In response, and that's fine for them to have misremembered, that's why we have body cameras. In response, Alexee stated to Dr. Vasquez and the officers, I'm sorry, it came out of me. I didn't know what to do. She went on to recount tearfully that it was not crying or nothing. Alexee later explained to the treating nurse that she had held the baby and that there was no movement, no breathing, nothing. We'll go up really quick, back to the bottom of this. Alexee's room and the position of the involved actors relative to the doorway. The footage demonstrate that the three men, two armed officers and charge nurse, stood either inside or in front of the only exit. I don't think that's accurate as to how they were standing. Number 7, the trial court's findings and conclusions record Dr. Vasquez's statement in an apparent typographical error as we discovered a baby in the bathroom. The body camera footage reveals that Dr. Vasquez clearly said, we discovered a dead baby in the bathroom. Yes, well, far more accurate. Also, in an apparent typographical error, the court's findings and conclusions record Alexee's statement as, I'm sorry, if it came out of me, I didn't know what to do. So the judge, this point 8 down here is saying that the judge who ruled on this said that if it came out of me, I didn't know what to do. So That's a little interesting. The judge misheard the actual statements on there. It came out of me and I didn't know what to do. So the judge thought that Alexee didn't even concede that this was her baby. That's wild. It kind of calls into question the judge's decision, in my opinion. Okay, we can keep going. It was only after this confrontation and Alexee's responsive statements to police that Dr. Vasquez acknowledged Alexee's medical emergency for the first time. No, she didn't, because she called for her to be transferred, noting Alexee needed to be airlifted to the nearest regional hospital. Immediately thereafter, and less than 3 minutes after entering the room and blocking the doorway, Officer Williams confirmed that Alexee was detained and not free to leave. The officers remained in Alexee's room even as medical staff performed another vaginal explanation until Alexee was finally airlifted to Lovelace more than 2 hours after Dr. Vasquez determined that she could die from postpartum hemorrhage. Actually, I don't know if they fully started the vaginal exam or whatever, but the officer did leave the room at some point when she got treatment. So, yeah. 5 months later, on May 18th, 2023, Alexee was charged with 1 count of first-degree murder, or in the alternative, child abuse resulting in death, and 1 count of tampering with evidence for the loss of her newborn. Number 9, the state omits key details of this interaction, characterizing the officer's language as polite and highlighting their suggestion to Alexee's mother, made well after the they're bringing in Rosa, guys. Remember how I called it Rosa's interrogation of Alexee? They're mad because she is not a state actor in any way. They can't blame her being in the hospital one way or another. They have to say that basically to argue that Rosa's statements aren't valid, they have to completely say that the cops can't even be in the hospital room, which is a very tough argument to make. And so everything that Rosa pulled out of Alexee is pretty much fair game, I've always thought. So, because the officers are allowed to be in the room. So, the state omits key details of this interaction, characterizing the officers' language as polite, which they were, and highlighting their suggestion to Alexee's mother, made well after eliciting the statements they sought from Alexee. No, they didn't. That she wait to engage with her daughter. The state mischaracterizes this interaction as an attempt by police to protect Alexee's right against self-incrimination, when in reality, the officers only addressed Ms. Rodriguez after nearly 7 minutes of interrogation. Nuh-uh. Officer Anaya recognized the significance of Miss Rodriguez's presence, noting it was probably the best mom's out of the way for now if she starts filling her head and starts telling her all kinds of different things. What the state frames as a protective intervention is, and hold on, we're going to go past and find the rest of this, is revealed by the officers' candid discussion as an attempt to neutralize Ms. Rodriguez's potentially mitigating influence or her ability to articulate Alexee's legal rights, which is a non sequitur. They separate people at the scene of crimes all the time. Like that's completely valid. That's bad argument. Right, we continue with the regular parts of the pleading. Through counsel, Alexee moved to suppress the statements made in response to the confrontation coordinated by Dr. Vasquez and law enforcement. The trial court granted appellee's motion, and the state now appeals. Argument. The trial court properly suppressed Alexee's statement to hospital staff and law enforcement. The Fifth Amendment to the United States Constitution affords criminal suspects a fundamental right against self-incrimination. The 14th Amendment makes that right applicable to the states. A lot of citations. New Mexico State Constitution similarly and independently protects this right against self-incrimination. Consistent with this broad and fundamental right to remain silent in the face of criminal accusation, this court must suppress custodial statements taken without protections articulated by Miranda v. Arizona, one of the most famous cases in all of law. Right? A criminal suspect cannot invoke her Miranda rights anticipatorily. Like, they can't anticipate that they're going to need to invoke Miranda. Rather, these protections are automatically triggered during a custodial interrogation. A suspect is considered in custody if a reasonable person would believe that he or she was not free to leave the scene. Interrogation under Miranda refers not only to express questioning, but also to, quote, any words or actions on the part of the police, ... that the police should know are reasonably likely to elicit an incriminating response from the suspect. Where police engage in a custodial interrogation, they must either read a suspect their Miranda rights or obtain knowledge intelligently, obtain a knowing, intelligent, and voluntary waiver of those rights. Here, the collaboration between police and medical staff to question Alexee never happened. Their knowledge of her pregnancy, the armed officer's physical presence within the room as they blocked Alexee's only exit, not accurate, and the inherently accusatory statement, "We discovered a dead baby," combined to create a custodial setting. Okay, so they're pulling stuff out of thin air. It just doesn't really rise to that for me, but I mean, the police are there for a reason, and technically, yes, you have a Fifth Amendment right to incriminate, to not incriminate yourself, but to not, you don't have to self-incriminate. But after committing a crime, it is very likely that the police are going to get involved. What you say and do after that, until you ask for a lawyer or invoke your Fifth Amendment, is not really needing Miranda until the police themselves attempt to interrogate you or ask you questions directly about the situation, which none of these police officers did. So I just see this different than them, but of course they're for the defense here. The trial court correctly determined that police, with Dr. Vasquez acting as their agent, employed statements and actions that any police officer should have known were reasonably likely to elicit an incriminating response, and that the reasonable person in Alexee's position would not have felt free to leave. Because police failed to inform Alexee of her rights under Miranda, and because Alexee never provided a Miranda waiver, Alexee's statements made in the presence of the police must be suppressed. Not all statements made in front of the police are subject to Miranda. Maybe once they said you're not free to go, but everything before that is not subject to Miranda. The doctor is not a police officer and no one asked the question. I just don't see it that way. The police are allowed to stumble upon you as a suspect to a crime. And the hospital and people who work in a hospital, staff of medical institutions, should be allowed to point in the direction of a potential criminal. They shouldn't have to keep that to themselves and hinder a police investigation. That's just it doesn't make sense. Standard for review for determining a Miranda violation. When a person is subject to custodial interrogation and entitled to the constitutional protections of Miranda is a mixed question of law and fact. The court determines de novo whether which means new every time, whether a police interview constitutes a custodial interrogation. Applying the law to the facts established by the district court, this court must accept the district court's factual findings, quote, unless they are clearly erroneous, and view the evidence in light most favorable to the district court's ruling. Which basically what they're saying there is the Supreme Court has to find that since these statements have been suppressed, that really the district court seriously erred in doing that originally, and give them back. That's basically all it says, which is completely likely. It's totally possible. In cases where police fail to provide a Miranda warning to a criminal suspect under custodial interrogation, the state must prove, quote, by preponderance of the evidence that the defendant knowingly, intelligently, and voluntarily waived the constitutional right against self-incrimination. Importantly, every reasonable presumption against waiver is indulged at both the trial and appellate level. So they're saying, essentially, we're just trying super, super hard to protect the fact that she did not want to incriminate herself. Alexee was subjected to a custodial interrogation. Police, without providing Miranda warning or receiving a waiver, with Dr. Vasquez operating alongside as their agent, cornered Alexee in her hospital room, doesn't have anything to do with an interrogation, while confronting her with a statement any reasonable officer should have expected to elicit an incriminating response. Here's where I'm going to argue with that. You know when you get pulled over by a cop and they say, "Where are you going? Where are you coming from?" That is a statement that could reasonably elicit an incriminating response. The person could lie to the police, which could be used against them in the future. They could say they came from a bar, and then they could get a DUI because they have been drinking. There is a lot of statements or questions that police can ask that will elicit an incriminating response, but they are still allowed to do so. And guess what? The police, and no one asked Alexee a question. She just reacted to the statement, okay, that was presented to her. That's all. So anyways, that's just my little rant on that part. For that reason, the trial court correctly suppressed Alexee's statements. The state attempts to reframe these facts to reach a different conclusion should be rejected. Number one, Dr. Vasquez acted as an agent of law enforcement. Stupid. Before addressing the circumstances of the custodial interrogation, the court should first affirm the district court's finding that Dr. Vasquez abandoned her role as a physician and instead aligned herself with police to further their investigation and interests. There's no proof of that. There's no proof of that whatsoever. They're just assuming that based off the situation. Dr. Vasquez should be able to testify as to whether she intended to help with the investigation or not. The record supports this finding, as Dr. Vasquez, knowing that Alexee had been pregnant and just given birth, refused to treat or speak to her without police present. That's a mischaracterization of the facts, and instructed staff to wait for police to arrive before interacting with Alexee, conferred with police before entering Alexee's room, and then confronted her as part of an unified law enforcement contingent, prioritizing a police interrogation over the medvac transfer that Alexee knew would be necessary to save Alexee's life. Okay, false, 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 false. She had already called to get it there, and we have the footage of Alexee getting on that helicopter, and guess what? It was like way after all this, because they don't just show up. There's not just a helicopter upstairs and they're like, get up on that helicopter. We have one waiting for you. They're in the middle of nowhere, Artesia. The helicopter got dispatched to them, most likely. So, no, they did not just willy-nilly say, there's a life flight up there for you, but wait until the police get to talk to you. This is so disingenuous. Sorry for getting so upset about this, but completely disingenuous. Although the Miranda rule typically applies only to government actors, courts have also clarified that government agents may not circumvent by acting through private citizens, which they didn't. To determine whether a private person is acting as an agent of law enforcement so as to trigger applicable constitutional protections, New Mexico applies a two-part test. The court considers first whether the government knew of and acquiesced the intrusive conduct. Second, whether the person acted with the intent to, quote, assist law enforcement efforts to further his or her own ends. Own ends? Doesn't seem like the doctor had any stake in whether the police made an arrest or not of Alexee. And as part of the first prong, they didn't acquiesce the intrusive conduct. They didn't go to a doctor and say, hey, I think this person you're treating did something bad. Can you ask them about it or do something about it? That would be completely different, right? You think the person's a drug dealer. You're like, can you ask them about the drugs that are on, if they have exposure to drugs, something like that, maybe get them to admit to that and then come tell me or let me overhear it, right? That would be an officer trying to get a doctor to acquiesce and have intrusive conduct on someone. That's not what happened in this case, in my opinion, at all. Let's read our little footnotes here. Number 10, Dr. Vasquez was not the only one to abandon her role as a medical provider in favor of adopting that of a police investigator. So you could just become an investigator. I'm a police now. Sorry, I was a doctor 5 minutes ago. Can you go get me my uniform, please? I brought it to work with me today. I'm going to change out of my doctor coat and put on my investigator uniform. The charge nurse, without having met, let alone treated Alexee, assumed the role of investigative helper, they're salty. They're just boo-hooing. They're going to hate what I have for them for HT. I have so much fun stuff ready to just pump up HT because I think he's awesome. The role of being investigative helper, being the first to share with police his unsubstantiated theory that Alexee entered the restroom secretly aware of and with the intent to harm her pregnancy. I mean, you guys are the one who admitted she ran down the hallway holding her butt, but that was you. Okay, we can continue. Our last thing was to assist law enforcement with his or her own ends. This is back to the arguing that Dr. Vasquez is a police officer now. Dr. Vasquez's actions satisfy both prongs of the Santiago test, and the district court correctly held that at the time she confronted Alexee, Dr. Vasquez was not acting as a healthcare provider, but instead as a collaborator with and instrumentally of the police department. That's crazy. The police were aware of and acquiesced Dr. Vasquez's interrogation of Alexee. Oh, so she's gonna, I'm saying she, because I'm pretty sure Amber Fairberg, like I said, wrote this, but let's get into this part. She's going to explain. To satisfy Santiago's first prong, government knowledge and acquiescence, the record must include some evidence of government participation in or affirmative encouragement of the intrusive conduct. Here, the record is replete, which means like it has a lot, is replete with evidence that the officers not only participated in Dr. Vasquez's interrogation, but affirmatively coordinated with her to do so. At the time of the confrontation, officers had already decided Alexee was a suspect in a potential homicide. Yeah. Indeed, moments before agreeing with Dr. Vasquez to confront Alexee as a collective body, the officers took a statement from the charge nurse who told them that Alexee, quote, killed the kid and was, quote, gonna lie when confronted. Footnotes: while Santiago factors are generally applied within the context of the Fourth Amendment, oh, well, would you look at that? So the Fourth Amendment, your right to unlawful search and seizure, is when this is actually usually applied. But they're going to try and apply it to the Fifth Amendment here, guys. While it's usually applied in the context of the Fourth Amendment, courts have also applied them within the context of Miranda. And so they're just wanting to let you know they can do it this way, even though it's not usually done that way. While the charge nurse played an outsized role in the initial steps of the investigation, he was not a member of Alexee's treatment team and therefore did not witness or have direct contact with Alexee until he joined forces with the interrogation team, which his name, charge nurse, kind of just like disproves that because he was relayed information about Alexee's treatment throughout the course of the night. Let's continue. The officers were active participants in the confrontation, thus satisfying the first prong of Santiago. In determining B, Dr. Vasquez abandoned her role as physician and became a magical police officer. In determining when the conduct of an otherwise private actor satisfies the second Santiago prong, the paramount consideration is whether the private actor had an independent motivation for conducting the search or seizure beyond assisting law enforcement. Okay, see, this is where it's Fourth Amendment because it's like conducting a search or seizure. I thought we were talking about Miranda. This factor thus requires a showing that Dr. Vasquez had no independent reason to interrogate Alexee, and she didn't interrogate Alexee in the presence of law enforcement, and that she was instead motivated primarily by an intent to assist police in their investigation. Dr. Vasquez spoke to police at length in the hospital and later in a separate interview. At no point did Dr. Vasquez ever articulate an independent motivation for her refusal to speak to her patient outside of police presence. That's so disingenuous again. Instead, her conversations with police repeat an affirmative willingness and desire to assist and work with them. As a physician charged with caring for her patient, Dr. Vasquez's quote own ends. Okay, so they're going to get to own ends here because I'm like, what's her own ends? She has no, rhyme or reason. Nothing comes out good or bad for Dr. Vasquez in this. Dr. Vasquez's own ends should have been to prioritize Alexee's emergency, active hemorrhaging, and need for medevac transfer. Oh my gosh, let me at these oral arguments, please. Just let me at them. Let me in, coach. Come on. This is crazy. Yes, she did. She met up with police after starting that process. She called, got her transferred. It just so happens the police got there very quickly. Please state if you hear me. If the person who is going to do oral arguments or who is doing the arguments after this, please, it was just that they got there fast. Keep harping on that. The police just got there fast. That's all. No one waited and lied in wait. It was just boom. The timing. The universe wanted Alexee to get caught. The cops got there so fast. They were there when Rosa had asked for Alexee to go to the bathroom. If you go back to one of my video about Rosa, there is that bombshell moment that we caught on the body cam footage that the police were there for a different matter when Rosa asked for Alexee to come out of the bathroom. So they would happen to just be right by. They just came right back. Okay, this is not lying in wait trying to catch Alexee because they found this baby and they were so mad at Alexee. That's just not what happened. A physician charged with caring for her patient's own end should have been to prioritize Alexee's emergency, active hemorrhaging, and need for a medevac transfer while maintaining her patient confidentiality, behaviors that medical ethics and protocols mandate. Instead, Dr. Vasquez, who knew Alexee was pregnant and who saw Alexee presenting with symptoms of impending labor and delivery as well as pregnancy complications, abandoned her obligations to provide her medical care and chose instead to align herself with the police investigation. Having abdicated her obligations as a physician, Dr. Vasquez instead acted as an agent of police. The American College of Emergency Medical Physicians guidelines emphasize the importance of patient care over collusion with law enforcement. I'm not going to read all this bull crap. she didn't breach her. Oh, let's read this. Relatedly, Dr. Vasquez breached her duty to inform Alexee of critical information about her condition, recognizes as a legal obligation. I don't believe this. I'm going to ignore these footnotes here. The state's argument that law enforcement was merely present for security purposes, not investigation, are without merit. No plausible reason can justify the need for two armed officers to, quote, secure the bedside of a high school student, 19-year-old woman who lay hemorrhaging after a traumatic labor and delivery. Indeed, the state concedes that neither Alexee nor her mother posed any threat to medical staff. The only plausible explanation for the police presence was to investigate. Alexee, with Dr. Vasquez serving as the conduit. Even assuming arguendo that basically saying, let's just say that law enforcement was present merely for security, Alexee's statements are still inadmissible. When an officer is present solely for security, the officer acts as an agent of the physician, thereby preserving the physician-patient privilege. See State versus Salas. The state cannot have it both ways. Either Dr. Vasquez invited police into Alexee's room merely as security for this. Who's even said that? Merely as security for the sole purpose of medical treatment, in which Alexee's medical privileges remain intact, or she invited them there to confront Alexee as a suspect in a homicide, a circumstance that necessitates the application of Miranda. The facts support the latter. I do not believe, and so I was going to say the latter is the one that would essentially attempt to be applied to this, but I just disagree. She didn't invite them in there to confront Alexee as a suspect. She showed them where a potential suspect was. She said, I haven't talked to her yet. I have to go tell her this. Would you like to come with me? That's all. That's all. The state's reliance on People versus Salinas to support its contention that Dr. Vasquez sought police presence for her own physical safety is thus unavailing. In Salinas, police brought the suspect to the hospital for medical purposes, and crucially, the physician had no prior coordination with law enforcement and did not request their presence and did not intend to assist the police in asking questions of the defendant solely for medical treatment. These facts are a far cry from those in the present case. Here, Dr. Vasquez not only requested police presence, but directed her staff to avoid speaking to Alexee without police present. That's weird because the police were let out of the room. Despite the uncontroverted fact that Alexee posed no security risk, and in this case, Dr. Vasquez initiated the interaction with an accusatory statement implicating Alexee in a crime, which she didn't. She just said we found a dead baby in the trash. She didn't say we found your dead baby in the trash. Huge difference. Take note, take note. She didn't say we found your dead baby in the trash. She just said we found a dead baby in the trash, and Alexee knew it was hers. So, be that as it may, the state's argument fails. Ugh, that makes me mad. The state's argument fails, and the court should uphold the district court's findings that Dr. Vasquez acted as an instrument of the police. Number two, Alexee was confined to her hospital room and not free to leave. I slightly agree with this. They told her she couldn't leave. So, like I said, I'll be honest when I think something is in their favor. The state argues that Alexee was not in custody because she was not formally arrested. Yeah, when she made when she made a boatload of her statements, she was not in custody. As soon as they said you're not free to go, I'm fine with turning off the faucet. I'm fine with that. Let's have everything be, open and allowed in court up until they say she can't leave. I will concede that 100%. The state argues that Alexee was not in custody because she was not formally arrested. Her, quote, freedom of movement was not physically or overtly restricted by police, and her statements were made before police explicitly told her she was being detained. Exactly. These arguments fail when determining whether an individual is free to leave. Courts consider several factors, including the extent to which the defendant is confronted with evidence of guilt, the physical surroundings of the interrogation, the duration of the detention, and the degree of the pressure applied to the defendant. No pressure was applied. Even a cursory review of these factors shows that a reasonable person in Alexee's situation would not have felt free to leave. Yeah, I agree, but not until she's told she can't leave. At the time, I would have said, get out of my room. Like, if I was Alexee, and she's 19, she should know her rights. As soon as the police enter, I should say, I want a lawyer, go away. Boom. If she knew her rights, then that's what she would have done. But she didn't, and she said stuff before the police actually detained her. So I find that all to be They can't. They're saying you can't have it both ways. Well, you can't have it both ways. The doctor can't be a medical person asking them to come in medically and be around them, or a police officer. Like it's one of both ways. And even if they are a police officer, she's allowed to go and confront someone. Right. And so like they're kind of trying to have it both ways. It's like, is she a doctor or is she a police officer? No, you guys want them both to be considered both, just because they happen to run into each other in the hallway before the doctor was able to get to Alexee. The doctor didn't intentionally wait to tell Alexee. She just invited the police along with her when she had the ability. Point blank, period. At the time of the police confrontation, Alexee was a 19-year-old woman, high school student cheerleader, who 3 hours earlier had been unaware she was pregnant. They used 3 hours probably because of the precipitous delivery. They're saying 3 hours because they're trying to claim she had precipitous labor, that she had no clue what was going on, and boom, just went into labor and had the baby, which I disagree with, but that's just me. 3 hours earlier, had been unaware she was pregnant and had been given an array of mind-altering drugs for pain, and had experienced a traumatic labor. So why didn't she call for help if it was traumatic? When police entered Alexee's room with her physician, Alexee lay only in her hospital gown, bleeding profusely and reporting the delivery of a stillborn alone in a hospital room. The confrontation occurred in a small treatment room with several adult authority figures, a physician, male charge nurse, and two armed male criminal investigation. What? Oh, sorry. And two armed male police officers who blocked her only exit. These authorities figures had already initiated a criminal investigation with Alexee as their only suspect in what they immediately deemed a homicide. The custodial nature of the encounter was underscored by the initiating words of the confrontation. We discovered a dead baby in the bathroom. This unequivocal accusation of guilt. No, it doesn't. Why is that guilt? See, your true colors are showing. You guys think that was an accusation of guilt. If the baby had been found to not be born alive, Alexee would probably not really be facing any charges at all. I think that's the point blank period truth. I think the baby was born alive. The autopsy is extremely strong, and that's why Alexee is charged with murder. So it's not an unequivocal accusation of guilt unless you feel guilty. It's just a statement. She could have been like, yeah, why are cops here? I had a stillborn and I didn't want to tell anyone. I think that stuff would have changed a little bit, but they got real weird real quick as far as the Trevizos and everyone. They kind of knew they were guilty, in my opinion, because they were, we can remember what Rosa said to Alexee. I just asked you to tell me the truth. So the unequivocal accusation of guilt made by a collective force of authority figures undoubtedly placed immense psychological pressure on Alexee by characterizing their findings as a criminal matter. Within minutes, Sergeant Anaya confirmed the custodial nature of the interaction with the definitive statement that Alexee was being detained, was in a police custody, and was not free to leave, after which point still did not advise her of her rights. Let's read this footnote. When asked, Alexee stated that she held a newborn she delivered and that it did not breathe, move, or cry. Alexee's account of stillbirth is further corroborated by the bleeding she experienced leading up to birth, the precipitous nature of her labor and delivery, and by Dr. Vasquez's determination to not attempt resuscitation of the deceased newborn only 30 minutes after Alexee left the bathroom, immediately pronouncing the newborn deceased at 2:28 a.m. No one in the hospital, however, considered the possibility that Alexee was, in fact, a high school student in the midst of an crisis who endured a stillbirth. Despite being one of the few people who actually knew Alexee was pregnant and could be in active labor, Dr. Vasquez admitted that she considered Alexee to be duplicitous from the moment of their first interaction, while the charge nurse, having never even spoken to Alexee, assured police Alexee would lie. This characterization inevitably informed Dr. Vasquez's accusatory confrontation and the nature of Alexee's response to it. Okay, that's their little footnote. I entered the room where Alexee was, and I advised her she was being detained and not free to leave. From the moment Sergeant Anaya, Officer Williams, Dr. Vasquez, and the charge nurse entered the room, Alexee was not free to leave. That is not true. That's actually an outright mischaracterization. That's just flat out not how it happened. You admit prior that the doctor said here's what we found, here's a dead baby in the trash, all this conversation happens, and then they tell her she's not free to leave. So you can't have it both ways. The state's reliance on factually inappropriate cases, or in opposite cases, does not change this conclusion. Defendants were informed that they were free to leave, which was not the case here. Instead, as soon as presented with the opportunity, Officer Williams confirmed that Alexee was not free to leave. The state's cited case law fails, therefore, to provide meaningful guidance to this court. The state also unpersuasively cites to Waiver. In Waiver, the appellate court held that the defendant was in custody when handcuffed and made to sit on a sidewalk while she was not handcuffed. Even without a confirmed arrest warrant. The court emphasized that the physical restraint and restricted movement were key factors, not a confirmed arrest. The same factors apply here, where armed officers blocked Alexee's only exit from her small and now crowded treatment room while her physical state was deteriorating. Contrary to the state's analysis, these factors created a restrictive environment equal to that in Waiver. Equally unavailing is the state's reliance on Salinas for the proposition that police presence in a hospital does not constitute custody. Salinas, however, stands for no such proposition. There, the court never even considered the question of whether the defendant was in custody once in the hospital, rendering the state's reference to Salinas in its custody argument utterly unhelpful to the court. The state's reliance on Berkmer is simply misplaced. In Berkmer, U.S. Supreme Court held that a brief public roadside questioning during a traffic stop did not constitute custody due to its minimal isolation and lack of intimidation. By contrast, Alexee's questioning was replete with both physical and psychological domineering pressure. Not true. Finally, the state misapplies the reasoning in People v. Davis and State v. Cobb. In each of these cases, police questioning occurred in unquestionably neutral or familiar locations. In Davis, the defendant had a large degree of freedom of movement within his own home. The conversation with police remained casual, while the accused at one point retrieving a football jersey to show off to an officer. The same is true of Cobb, in which there was no evidence of police limiting the defendant's freedom of movement within his own home. Similarly, in Sullivan, as in Berkmeyer, the routine questioning took place during a traffic stop. In that case, the suspect was in full view of a public highway when asked if he had anything illegal in his car. Alexee, in contrast, was in the private confines of a patient room with two armed officers, not only limiting her freedom of movement, but actively blocking her only exit. The state's argument fails to show that a reasonable person in Alexee's position would have felt free to leave and should be rejected. A reasonable officer should have recognized Dr. Vasquez's statement as one reasonably likely to elicit an incriminating response. They didn't know what she was going to say before that. So interrogation need not consist of direct questioning, but can include its functional equivalent. Supreme Court put in Rhode Island versus Innis, which is one I did read, any practice that police should know is reasonably likely to invoke an incriminating response from a suspect, thus amounts to interrogation. See also State versus Juarez, which is another one I read. Interrogation is not limited to express questioning. It can include other less assertive police methods that are reasonably likely to lead to incriminating information. Dr. Vasquez's flat statement, "We discovered a dead baby in the bathroom," is one any officer should have perceived as reasonably likely to elicit an incriminating response. This statement did not convey general information, but served an accusation of guilt, especially given the coercive atmosphere of armed officers and medical staff crowding a small treatment room and Dr. Vasquez's medical knowledge of Alexee's precipitous delivery. That accusation could only implicate Alexee, as she was the only one who lay bleeding from having just given birth. The court's reasoning in State versus Ybarra supports this interpretation. There, passive police presence during a nurse's questioning of a suspect was found to constitute a constitutional interrogation because the police, quote, took advantage of the emergency room's inherently coercive atmosphere, subjecting the defendant to circumstances which they knew or should have known were reasonably likely to elicit incriminating responses. Even passive or subtle police conduct can spark the need for Miranda warnings. Just because police are there. I mean, maybe should we make that the standard? But that's not currently the standard. Anytime a police officer talks to you, it's like, hello, you have the right to remain silent. Do you know how fast you were going? I'm definitely going to stay silent after that. So I can get behind that, but that's not the standard right now. Artesia police officers took advantage of the psychological coercion a teenager would inevitably feel in the face of three imposing authority figures, all of whom knew of her traumatic delivery and turned that fact into an accusation of wrongdoing rather than a medical concern. The state attempts to refute this otherwise intuitive conclusion by unpersuasively relying on Innis. In Innis, the defendant was arrested, read his Miranda rights, and requested an attorney. During his subsequent transport, officers casually discussed the potential dangers of a missing gun, which the defendant overheard. Unprompted, the defendant inserted himself into their conversation that led the officers to the weapon's location. The court found that the officers' remark did not constitute interrogation or its functional equivalent because they were, quote, nothing more than a dialogue between two officers to which no response from respondent was invited. Sounded a lot like Alexee's case. And they could have not foreseen that it would provoke the defendant's interjection. The facts are stark in contrast to those in Alexee's case. Unlike the subtle compulsion of Innis, there was nothing subtle or conversational about the group's entry into Alexee's room. Dr. Vasquez's statement was a clear coercive action, likely to elicit exactly the type of incriminating response against which Miranda protects. Again, the police, who Miranda applies to, did not know that would be the statement and did not know that that would be the response. Lastly, the state corrected, but ultimately unhelpfully cites Waiver for the proposition that routine questions, such as asking for identification, do not typically trigger Miranda protections. This is irrelevant as the issue here is not Sergeant Anina's request for Alexee's driver's license, but the confrontational statement of her physician. While routine identification does not constitute interrogation, Waiver distinguished between routine inquiries and those directly related to the alleged commission of a crime. Oh, well, isn't there an alleged commission of a crime in this case? In Waiver, an officer's question about contraband was found likely to provoke an incriminating response constituting an interrogation. But again, no one who was an officer asked Alexee any questions. The statement, "we discovered a baby," statement, not question, is likewise an accusatory statement directly related to the elements of the crime under investigation and therefore constitutes an interrogation. So how fast were you going in interrogation? Do I need to be Mirandized before I'm asked that by a police officer? I just want to know, because what's the standard then? It doesn't make sense, at least not now. Alexee has never waived her Miranda rights. Alexee was subjected to custodial interrogation and, as is undisputed, never received Miranda warnings. The state must prove that Alexee waived the rights protected by Miranda and that any alleged waiver resulted from a free and deliberate choice rather than intimidation, coercion, or deception, and was made with full awareness of both the nature of the right being abandoned of the consequences of the decision and the consequences of the decision to abandon it. Courts evaluate the totality of the circumstances in determining whether the state has met its burden, considering factors such as the accused's mental and physical condition, background, experience, and conduct, as well as the conduct of the police. Wait, are we just going to ... after conduct? Because is it her possible conduct, Alexee's conduct, and the conduct of the police? Just forget about her conduct having anything to do with the burden here. Just saying. In this case, no evaluation of waiver is necessary as neither officer provided Alexee with the warnings and rights articulated under Miranda, and Alexee therefore remained completely unaware she had any rights to waive. The trial court properly considered the totality of the circumstances and properly applied the law to those facts, viewing these facts in the light most favorable to the district court's ruling and applying every reasonable presumption against waiver. This court should affirm the district court's findings. The trial court correctly found a violation of the physician-patient privilege. New Mexico has long upheld the fundamental privilege of patient privacy enshrined in Rule 11-504 with roots dating back to the state's territorial period. As early as 1880, Rule 11-504B renders inadmissible confidential communications made for the purpose of diagnosis or treatment of a patient's physical, mental, or emotional condition between the patient and the patient's physician. New Mexico courts have consistently recognized that protecting patients' confidentiality fosters trust between patients and providers and facilitates effective treatment. Sorry, I went too far. We can, no, I didn't. We can get past. Dr. Vasquez violated Alexee's right to medical privacy by discussing her medical condition only in the presence of law enforcement. The district court's holding is grounded in the unassailable principle that patients must be able to disclose sensitive medical information fully and without fear that it will later be used against them in court. The ironic part about that statement is if Alexee had just told the truth about what happened without fear and was, actually disclosing sensitive medical information to her medical provider, none of this would have happened. Take note of that argument. Jeez Louise, these people just twisting the truth, in my opinion. We can continue. Exclusion. Oh wait, that means I missed something here. Sorry. Without fear of it in court, refusal to compel a defendant's privileged communications in a criminal case, upholding suppression. Exclusion of medical records and negligent action. Okay, the state attempted to override the privilege. Relies on two unfounded claims. One, Alexee voluntarily waived her privilege, and two, that mandatory reporting requirements create a blanket waiver of medical privacy. Both arguments lack merit. No, they don't. The trial court did not abuse its discretion in excluding privileged communications under Rule 11504. This court reviews the exclusion of evidence for an abuse of discretion and will reverse only in case of clear abuse. Noting that an abuse of discretion occurs when a ruling is clearly against the logic and effect of the facts and circumstances of the case. Well, that's not pretty applicable to this situation. To meet this burden, the state must demonstrate that the trial court's decision was clearly untenable or not justified by reason. Defining abuse of discretion as applying an incorrect standard, incorrect substantive law, or its discretionary decision is premised on a misapprehension of the law. Internal quotation marks and citation omitted. Interesting. The district court did not abuse its discretion, but reasonably perceived Alexee's medical privacy by upholding protections guaranteed by law. B. Mandatory reporting does not strip patient privacy protections. The state repeatedly asserts the entirely unsupported and untimely dangerous argument that the hospital's perceived mandatory reporting obligation of the deceased newborn to police nullified Alexee's medical privacy rights from that point forward, which I completely disagree with. See, let's read that again. The state repeatedly asserts the entirely unsupported, pretty sure that's in Rule 11504. The one you keep quoting, the one I've had to read a million times. The state repeatedly asserts the entirely unsupported and untimely dangerous argument that the hospital's perceived mandatory reporting. They just perceive it. It's not, codified in law, Rule 11504, which you keep referring to. That's wild. Perceived mandatory reporting obligation of the deceased newborn to police nullified Alexee's medical privacy rights from that point forward. Yeah, that's literally how it goes. The state's assertion that Alexee's patient confidentiality was inapplicable after the hospital's reporting is supported by neither law nor relevant medical practice. The state's interpretation of mandatory reporting under NMSA 1978 asks this court to effectively rewrite the law. No, it doesn't. A power reserved solely for the legislature. We have said that only the legislative branch can, that they're just saying that only the legislator can make laws. Such an interpretation would have disastrous implications for patient privacy and public health. The state's attempted circumvention of the legislative process to dramatically expand Section 32A43 would convert medical providers wholesale into evidence collectors for the entirety of their interactions with patients suspected of criminal wrongdoing. No, it wouldn't. Let's read this footnote. The basis for mandatory reporting trigger was in itself hastily crafted. Alexee arrived at the ED bleeding and complaining of severe low back pain. Despite ED staff knowing she was pregnant, the administration of morphine, and despite Alexee's exhibiting symptoms of well-known pregnancy complications, she was permitted by staff to use the bathroom alone, unattended. In less than 19 minutes, she gave birth in the bathroom. These facts do not provide the staff with reasonable suspicion of abuse, but instead pointed to an easily diagnosed. Oh, so they're just completely, okay, this is complete bullcrap and a waste of my time to read. The reasonable suspicion of abuse wasn't that she just merely gave birth. It was how the baby was found twisted up in a trash bag. We will continue, so I'm not going to read the rest of that crap. Okay. Section 32A43 would convert medical providers wholesale into evidence collectors. Oh, we read that, and that's also crap. Hospitals are sanctuaries of care. Sanctuaries of care? Is science your religion? Not extensions of their local policy precinct. Adopting the state's position would mean that the vulnerable pregnancy patients would be chilled from seeking care for fear of having a potential tragedy met with the deprivation of dignity, denial of healthcare, and violation of patient privacy. I'll give you points for that. But I don't ever want to see this bull crap again in my life. They're twisting and saying that women aren't going to want to go and actually seek pregnancy help because this chick locked herself in a bathroom, put a baby in the trash bag, and the cops got called. That should scare all women. No. That's so crazy to me. Oh my gosh. The court should reject the state's invitation to disrupt this harmony in favor of unfettered police access, contrary to both the letter and spirit of Section A43, 32A43. Sorry. The state offers no legal authority to support its assertion that either Rule 11504D4 or Section 32A43 permits the broad intrusion into Alexee's medical privacy and merely posits the general proposition that rights have limits. Yes, they do, unfortunately. Sorry for you guys, but they do. Section 32A43, however, simply requires the reporting of a matter based on reasonable suspicion. It does not grant healthcare providers the prospective right to a full-scale breach of confidentiality or to involve law enforcement in confidential patient conversations or treatment. It does not justify the intrusive presence of law enforcement in Alexee's hospital room during her diagnosis and treatment. It does not endorse what the state characterizes as Alexee's moral duty to disclose her own medical trauma during a police investigation or to police hospital staff. I'll raise you one and say she should have disclosed her own medical trauma to the medical providers. How did they not know there was no baby up in there until they found it in the trash? Explain that to us. Because baby Alex was not made aware of by anyone. It was a medical anomaly as far as they were considered because they thought she was having the miscarriage actively. They didn't know the baby had already been born. So these points are really null and void. Indeed, the limits of a patient's privacy, rights to privacy are not as the state describes them. As the New Mexico Court of Appeals emphasized in Eckhart, even good faith compliance with mandatory reporting does not justify broader disclosures that violate the physician-patient privilege. In drawing the contours of patient confidentiality, Eckhart clarifies that the duty to safeguard patient confidence is an expression of public policy that is only waived in specific statutory exceptions or by voluntarily signing a release of information, which Alexee did prior to entering the hospital. The balance between reporting what a provider has reasonable suspicion to believe is child abuse and maintaining patient confidentiality is similarly reflected in ACEP's policy statement on law enforcement information gathering in the emergency department, which directs emergency medicine physicians to prioritize patient care, seek informed consent, perform only tests with medical indication, and permit police recordings in the emergency department only with the consent of all parties. Finally, the state's reliance on State versus Smith to argue for harmonizing statutes to avoid absurd or unreasonable results strains credulity. There is no conflict between mandatory reporting obligations and Rule 11504 to the extent that Section 32A43A applies to the facts of the present case, a matter that is itself arguable considering that medical staff made no initial attempt to determine the circumstances surrounding the birth or whether the newborn was born alive. Yes, they did. They looked at the baby, and they can't make that determination or not. The hospital's 911 call enabling police to initiate an investigation was sufficient to fulfill that obligation. The mandatory report is just that, a report to police of their findings and suspicion of abuse. That report does not and should not include an invitation to listen as Alexee describes her active crisis which she didn't, nor can it be used as a means to circumvent Alexee's fundamental right against self-incrimination. There is no statutory, medical, or moral duty for healthcare providers to take on the role of an investigator, which she didn't, as Dr. Vasquez did. No, she did not. And there is no plausible argument that maintaining Alexee's confidentiality and care provided that call would somehow lead to an absurd result. Smith requires courts to consider statutory history, function, and the broader legal framework when interpreting laws. The legislative intent behind the physician-patient privilege aims to protect patient confidentiality while defining a narrow exception to report suspected child abuse under Section 32A43. These laws can and do coexist while preserving patient privacy, and the exclusion of unlawfully obtained evidence is not only consistent with, but necessary to preserve this framework. Alexee's statements are privileged. Alexee's statements to Dr. Vasquez and hospital staff that she gave birth to a newborn that did not breathe, move, or cry is protected under Rule 11504. Such communications are privileged if 1, the patient intended them to remain undisclosed, and 2, non-disclosure furthers the patient's interests. Number 1, Alexee intended to keep her communications private. A patient's consent to diagnosis or treatment implies an intent to keep communications confidential. Under Rule 11504B, communications made for the purpose of diagnosis or treatment are privileged, which I argue that she wasn't trying to get her proper diagnosis or treatment, so none of her statements should be privileged, but that's just my off-the-wall argument. Alexee sought emergency medical care, and her communications with Dr. Vasquez were essential to getting that care. The forced presence of law enforcement, which Dr. Vasquez admitted was a condition of continued treatment, coerced Alexee into disclosing her precipitous labor and delivery in front of police in order to be transferred for emergency treatment. So they're really twisting it here. They're saying that they forced her to admit this in order to get her treatment. That's not how it went at all. That's like torture level of stuff. Like that's not allowed. That's not what happened at all. Alexee had such a long period of time, so many exams going on her before she gave any kind of, she didn't tell anyone she had a baby until the police were there. And so if she felt coerced into telling the truth about her crime, in my opinion, at that point, then that's on her. And she didn't need to be Mirandized, but they can't twist it like this. That's just not how it went. Alexee's communications were made only after being prompted by her treating physician with awareness of her continued bleeding and rapidly deteriorating condition. Just as the coerced presence of law enforcement does not automatically waive Miranda, nor does it waive the privilege under Rule 11504. The state fails to show Alexee consented to law enforcement presence or that she agreed to it as a condition of treatment. It was not a condition of treatment. Non-disclosure furthers Alexee's medical treatment interests. Prosecutorial public policy goals can be achieved without invading an individual's privacy and bodily integrity, with the physician-patient privilege seeks to protect. And yet, throughout her visit, medical staff and law enforcement repeatedly violated Alexee's privacy. Police were allowed to remain in her room to listen to confidential information and witness invasive examinations, despite the fact that there was no suggestion, let alone evidence, that the defendant posed a nature to the physician or other medical staff, other than the fact that she was going to sue them for the wrongful death of the baby that she put in the bag. But, I mean, I think that's a potential threat, just my opinion. The preservation of Alexee's physician-patient privilege is essential to protect her privacy and bodily integrity even now, and to refute the practice of conditioning continued care on the coercive presence of law enforcement. This is much ado about nothing, in my opinion. Alexee did not waive the physician-patient privilege, although Dr. Vasquez could have invoked Alexee's privilege to protect her privacy. Only Alexee, as the patient, held the privilege and thus had the authority to waive it. The state presents no evidence that Alexee knowingly or expressly did so. As the trial court correctly found, Alexee was never even afforded her right to invoke the physician-patient privilege. Additionally, the trial court correctly concluded the presence of her mother, listed as her emergency contact, does not undermine Alexee's privilege during the encounter. This is because Ms. Rodriguez, as Alexee's mother and emergency contact, was present to further Alexee's care and protected her interests. Nor does the mere presence of law enforcement automatically nullify Alexee's privilege, as the state argues. Courts routinely hold that the presence of third parties, even officers, does not destroy privilege if the communication was intended to be confidential or, as the state repeatedly argues, where law enforcement is present merely as security. Alexee's response to direct prompts from her treating physician while she was desperately in need of urgent medical care, as armed officers watched and listened, does not amount to a voluntary waiver of patient confidentiality. The state cited case law on waiver is unavailing, as it does throughout its papers. The state cited case law on waiver is unavailing. As it does throughout its papers, the state relies on several inopposite or inapplicable cases to support its argument that Alexee somehow waived her privilege. The state's reliance on or Bluntman versus Baker do not support an argument of privilege waiver. The court explained that waiver occurs through an express waiver, i.e., by putting one's medical condition directly at issue, or an implied waiver, which requires a clear, unequivocal purpose to divulge the confidential information. Well, I believe finding the baby in the trash would be a clear, unequivocal purpose to divulge the confidential information. It is undisputed that Alexee never expressly waived her privilege, and that the state has failed to provide evidence of any purpose to support a contention of implied waiver. Well, what about the waiver she signed? Rather, the cases on which the state relies affirm that the intention to waive privilege must be apparent. Brief, nondescript statements to investigating police officers will not suffice. And just as a waiver must be apparent, so too must it be voluntary, with the patient either disclosing information on her own or consenting to that disclosure. To support a claim of waiver, New Mexico courts require an affirmative voluntary act for waiver, such as signing a release. There we go. Boom, 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 boom. Finding that voluntarily signing a release of privileged information constitutes a waiver of that information. And yet, Alexee took no such actions, and the state fails to present any evidence to support a claim of implied waiver. The state has said that Alexee signed a waiver, and I tend to believe that the state will have that waiver. The state's comparisons to people in interest, state versus La Roche, and people versus Hartel are also unconvincing. The court held that a minor's voluntary answer to a physician's question, where the child stated that he cut his finger on a knife without any evidence of custodial interrogation or coercion, was admissible at trial. These statements, in stark contrast to those in this case, while made in the presence of an officer, were not, quote, in any way connected with an investigation of a crime, and were not made to a physician who, quote, knew nothing about the crime. Alexee's statements, in contrast, were elicited by a physician aware of and involved in a criminal investigation that was, by that point, well underway. Additionally, these statements cannot be considered voluntary, as Alexee made them under the pressure imposed by the presence of multiple law enforcement officers and authority figures who actively blocked her only means of exit. The state's reliance on La Roche is also unhelpful, as that case involved disclosure to EMTs, who are not bound by patient confidentiality laws in New Hampshire, unlike physicians in New Mexico. Similarly, in opposite as is Hartel, which the defendant made numerous statements to multiple parties before and after speaking with medical professionals, clearly not intending them to remain private. Unlike the defendant in Hartel, Alexee made her statements solely in response to Dr. Vasquez's prompt. The state also unpersuasively cites People v. Gomez, a New York trial court decision, where the court justified overriding physician-patient privilege due to the public health epidemic of controlled substance use. No such public interest exists in this case. The public interest that does exist here supports protecting confidentiality, as Rule 11504 was designed to encourage patients to seek care without fear of legal repercussions. Finally, the state relies on State v. Richardson, where the court permitted disclosure under mandatory reporting laws, a decision influenced by Ohio's recognition of fetal personhood. In Richardson, the court found that defendant's failure to disclose her pregnancy provided reasonable cause to suspect foul play, where she claimed the baby was stillborn, thus waiving her privilege on the basis that her fetus was a person. Okay, well, There you have that. Unlike Ohio, New Mexico laws found the born alive rule, which defines a person as a neonate that breathes spontaneously or shows signs of life after birth, right, which is what baby Alex is in most everyone's opinions based off the autopsy. Absent in legislative instruction, refusing to extend the definition of human being to a viable fetus, defining stillbirth as a fetus that after complete expulsion from the mother does not breathe spontaneously or show any other evidence of life, such as heartbeat, pulsation of the umbilical cord, or definitive movement or of voluntary muscles. In accordance with New Mexico's law that prohibits mandatory reporting based on drug use during pregnancy and thus prohibits prioritizing the criminalization of pregnant women's conduct over the provision of treatment, New Mexico protects pregnancy-related tragedies from automatically being scrutinized as criminal wrongdoings. This framework prioritizes patient privacy and underscores New Mexico's commitment to supporting the autonomy of pregnant women and their maternal and fetal health. The framework that supplies yet another basis for this court to affirm the ruling of the district court. Conclusion. Finally, guys, the district court's suppression of Alexee Trevizo's statements comports with the constitutional protections against self-incrimination and the physician-patient privilege. Upholding these protections is essential not only to preserving Alexee's rights, but to maintain trust in New Mexico's healthcare system for patients more broadly. For these reasons, the court should affirm the district court's order and reject the state's attempts to erode these essential protections. That was pretty much the entire response and the plea by the defendant to the Supreme Court to allow Alexee Trevizo, the defendant, to keep her medical privilege and all this evidence out of court, to not be allowed to be used against her. Now, this was my preliminary reading. You kind of got to read it along with me. I inserted a lot of my thoughts and opinions along the way, so I will spare you kind of the long rundown. What I think I will do is do a best argument and worst argument when it comes to this, the defense's answer brief to the Supreme Court. And from there, really quickly, I would like us to take a look at this document here. 2 days after the filing by the defense in this case, that document we just read, this attorney who has been brought on for the state to help with this appeal has now given a response 2 days later. So we're just going to read this really quick because after hearing all of that information, I think this information is extremely important. Appellant's unopposed motion to supplement the transcript of proceedings with the May 16th, 2023 preliminary hearing audio. State of New Mexico, by Assistant Solicitor General Michael J. Thomas, hereby moves for an order pursuant to Rule 12.1.211 NMRA, supplementing the transcript of proceedings in this matter with the audio from the preliminary hearing, probable cause hearing, held May 16, 2023 in the related district court case, which directly led to the underlying district court matter. Pursuant to Rule 12.309 NMRA, Defendants Counsel Gary Mitchell was contacted. Attorney Mitchell and co-counsel are unopposed to the relief sought, according to a 10/29/24 email from Attorney Mitchell's assistant. Despite being unopposed, the undersigned states as follows to establish good support case to support. Sorry, guys. Despite being unopposed, the undersigned states as follows to establish good cause in support of this motion. Number one, prior to the filing of the criminal information in the underlying district court case, a hearing was held in the related pretrial detention case, State versus Alexee Trevizo. The hearing concerned A, the state's motion for preliminary detention, and B, the preliminary examination of defendant to establish if probable cause existed to bind the matter to district court. Following the preliminary examination, the district court entered an order binding this matter based on sufficient probable cause as to all charges, including murder in the first degree, willful and deliberate. Order on preliminary examination, State versus Alexee Trevizo, essentially got moved to Judge James Gray. The criminal information was filed on May 18th, 2023 in the underlying matter, out of which this appeal arises. 2 days after the district court found probable cause existed as a result of the current matter, directly followed from the district court's ruling that probable cause existed. Let's read our footnotes. At that time, no probable cause hearing had yet been held in magistrate court. The magistrate court case was closed and the case was transferred to district court upon the filing of motion for pretrial detention. The undersigned has obtained a copy of the audio. The district court verbally ruled that probable cause existed as to all charges near the conclusion of the preliminary exam. The court followed that with a ruling with a written order. Okay, so we can continue. Number 4, the state did not need to initially discuss the preliminary hearing audio in the brief in chief, as it was not directly relevant given the limited legal issues concerning Miranda and the physician-patient privilege that were the subject of this interlocutory pretrial appeal. Additionally, the preliminary exam was held in a different, although related, district court case as referenced above, and such audio recordings would not be automatically included as transcripts available to the court on appeal. Let's keep it going. Number 6. However, in defendant's answer brief filed October 28th, 2024, defendant asserts that the victim newborn in this matter was stillborn or was a stillbirth, suggesting that the newborn was dead upon birth, at least suggesting that the incident involved a miscarriage or some other unavoidable medical tragedy. Defendant also refers to her statements that the baby was not breathing. Against that description, defendant omitted from her answer brief any of the material evidence concerning the cause and manner of death received at the preliminary examination. At the preliminary hearing, testimony was received from pathologist Dr. Schnoist of the Office of the Medical Investigator. The pathologist's testimony supports a conclusion that the manner of death was homicide and the cause of death was entrapment, i.e., that the baby was born alive when born, but died due to entrapment in a garbage bag in a trash can in which the baby was later found in the hospital bathroom. Although it is not clear if the related autopsy report by the same pathologist was admitted in evidence at the preliminary examination, the undersigned has also reviewed that written report, which is consistent with the pathologist's testimony. While defendant can later claim or assert at trial that the baby appeared to be dead upon being born, there is sufficient proof in the record that would support a fact finder in concluding that the baby was born alive but died due to defendant's actions in placing the baby in a trash bag and not alerting hospital staff. Oh, you guys, this is amazing. This is amazing. This guy did amazing. We said this before. We said that the baby being born alive or not needs to be decided by the jury. We've said this since we started the Supreme Court series. We said that over and over and over. That needs to be decided by the fact finder, the jury. They get to decide what actually happened in this. And he is throwing down that gauntlet here. And I love to see it. After reading all that hullabaloo and just, literally nonsense, this is refreshing. As a result of the referenced characterizations in the answer brief, even at this pretrial interlocutory stage, the evidence from the preliminary examination is relevant and even required for proper context. Darn Skippy. Accordingly, the preliminary hearing audio should, in fairness, be part of the record on appeal so that this court has a more complete view of the evidence that will be brought forth at any trial, even for the purposes of evaluating the legal arguments at this pretrial stage. While the undersigned can, as an officer of the court, accurately summarize the key medical testimony received at the preliminary examination in the reply brief due in November, this motion is filed to properly supplement the transcript of proceedings so that May 2016-2023 hearing audio is available to this court. Wherefore, the state of New Mexico asks that this court enter an order directing the district court clerk to transmit the audio from the May 16, 2023 preliminary examination. Essentially, what this is saying is they are making arguments that need to be done in front of the jury. The jury gets to decide whether the baby was born alive or not. And you cannot just characterize this as a medical tragedy with the rest of the facts in this case. That's just not how it's going to go. So I will try and keep this short, sweet, and to the point. The defense has tried to lay down the gauntlet that this is a medical staff being, overzealous with a woman's rights to the privacy of what happens in her pregnancy, which I think is just a completely losing argument given the facts in this case. And that response, that very quick response to supplement the record and get all of the testimony of the medical examiner entered as evidence for the Supreme Court to review is extremely hopeful, because I do find it to be a fact for the jury to decide, given the rest of the facts in this case. And I do think that the privilege that they think is going to be afforded to Alexee from the Supreme Court is likely to run out. Like I said, I will do a best and worst argument from this. This was my preliminary reading of this, and only gotten through essentially the first page and was unable to review it, but wanted to get you guys this information as quick as possible. So we kind of read it here together. First, I will go through those court cases that they've cited. I'll try and read up on any of the laws that they referenced that I was unfamiliar with. Most of what they were saying does just not really ring as applicable to Alexee's case, in my opinion. They all seem like great arguments for other cases possibly, but in this case, I just don't really see it. And so with all of that being said, I do hope that you guys see the light at the end of the tunnel. The state is going to be quick with their response due to this additional attorney being added to handle all of this appeal and all the steps that go with it. If there is oral arguments granted by the Supreme Court, just because the defendant asked for it doesn't mean that the Supreme Court will grant the privilege to have oral argument in front of them. If they do, though, they are usually live streamed. You can watch oral argument from the New Mexico court website. You can basically just drop in and watch oral argument and Supreme Court proceedings if you'd like. So if that is the case, we will definitely be trying to watch oral argument if they are granted such a privilege to be able to do that. It is a privilege, in my opinion, because it's a pretty cool and interesting facet of the law. If you look up oral argument, you can see some pretty cool and interesting legal things that you might not have usually seen based on how trials usually go. And you usually see trial attorneys in action, but not oral arguments. So very interesting, very cool, very nerdy piece of the law if you want to look into those. But for that being said, I will hit you guys with a video with the best and worst arguments out of this and try to explain in depth some of the cases that they are citing, if they are relevant or if they have any strength or validity to them. But until then, I hope this was a positive update, seeing the state's quick and snappy response, and we're getting closer and closer to the Supreme Court being able to make a decision and us getting to trial likely sometime early in 2025. Thank you so much if you made it this far in this video. If you have any comments, questions, or concerns, please leave them down below and I'll get back to you as soon as possible. And I do genuinely enjoy the conversation. If you're interested in following cases like the Alexee Trevizo case to trial, please subscribe because I'll be covering it all along the way with a legal focus. It's your Friday. I'll see you in the next video. Okay, bye.